So let me begin by saying a very warm welcome to the Law Matters seminar series with our special guest, Marc Thommen from the University of Zurich. Today, my name is Andreas Schlonnert. I'm a professor of criminal law here at the University of Queensland School of Law, and I'll be moderating this afternoon's presentation a little bit. This is also offered as part of the joint University of Zurich, University of Queensland, University of Vienna Transnational Organized Crime program. So a special welcome to the audience overseas. It's very early in Europe, and we have participants in Vienna, in Zurich, in Cologne, and in Ferrara joining us this afternoon here as well. It is my great pleasure, of course, also to acknowledge Turrbal and Yarraga people as traditional owners and the custodianship of the lands on which we meet today. On behalf of the University of Queensland, I pay our respects to their ancestors and their descendants who have continued cultural and spiritual connections to country. We recognize their valuable contributions to Australian and global society and acknowledge that this campus has always been a space for learning, for teaching, for research and collaboration tens of thousands of years before the University of Queensland was established, and it continues to be used for these purposes today. Just by way of background, Marc has studied law at the University of Basel, Fribourg, and Zurich in Switzerland. He did his PhD at the University of Basel as well, a Master of Law from the University of Cambridge, and his professoriate he gained at the University of Lucerne before moving back to the University of Zurich. I think you've got all the degrees that one can get in a lifetime, so congratulations. He is a professor of criminal law and criminal procedure. With that, over to you, Marc.
Thank you. Thank you, Andreas, very much for inviting me. And thank you all, and hello to you all for joining the seminar. It is still very early in the morning for me, so if there is some gap in the presentation, it's probably due to monstrous jet lag. Let me start this presentation with a puzzle. On April 7, 2015, a man got arrested at the airport of Zurich. He was boarding a plane to Istanbul. His arrest was based on a survey or on his online search history that was monitored. And the suspicion was that he was about to support IS in Syria. Now, roughly 2 years later, I boarded a plane to Istanbul. I gave a talk in Istanbul on terrorism and the rule of law. And the search history I did prior to this lecture in Istanbul must have been roughly the same than this person's search history. I'm here now, this person is in prison, and yeah, we'll probably talk about that case in the end of the presentation. I structure my talk into two main sections. In the first section, I will talk about organized crime, about its definitions and about its empirical relevance in Switzerland. And then in the second part, I will lay out the strategies to combat organized crime. My main claim or my thesis is that universally the combat against organized crime is aligned along what I call the 4 Ps: prohibition, proceeds, prosecution, and police. I will be talking much about the Swiss system because that's the only one I really know. But I'm very curious to hear what you say, or whether you see your combating of organized crime follows the same structure. Now, let me start with the definition of organized crime. This is the definition offered by the Obama administration in its strategy paper that gave the title to this presentation. I'm not going to read it out to you. I'm just going to highlight that also this universally throughout, you always have the same features popping up in these definitions, that criminal organizations are about obtaining power and commercial gains through legal or illegal means. They can be organized in clans, networks, and cells, and they act secretly or conspiratorially. The very same is true for the Swiss definition. I'm not going to read this out either, but we find more or less the same features in this definition as well. So it all comes down actually to the definition of the features that Interpol sets out in its definition, that criminal organizations are mainly aiming for profit through legal and illegal means they resort to violence and intimidation in their work. They're mostly set out as permanent institutions that are structured hierarchically, at least historically. And they make a great deal about their isolation or omerta towards the outside world, and they try to gain influence on politics and economy. Now, there has been much talk about the taxonomy of organized crime versus criminal organizations. I would claim that the main term is organized crime, and within that, criminal organizations are a subgroup. All criminal organizations, I would say, are organized crime, but not all organized crime does have all the features of criminal organizations. As you can see, or as we will see later, some forms of organized crime come in form of gangs or networks, and that are not strictly hierarchically structured as the typical mafia-style criminal organizations. Now, in Switzerland, we have this strict distinction between two different styles of criminal organizations. First, there are the mafia-style criminal organizations, the Cosa Nostra from Sicily, the 'Ndrangheta from Calabria, Camorra from Campania, and Sacra Corona Unita from Puglia. Obviously, as Italy is a neighboring country of Switzerland, these mafia-style Italian criminal organizations have been most prevalent in our realm. I assume that here other criminal organizations are active. But these are the traditional ones, the very hierarchical ones, the ones that are very secret within them. And their main aim is, and that's important for the distinguish, is to make profit, economic profits, through, for example, drug dealing. And the other main group are terroristic criminal organizations, such as Al-Qaeda or the FARC, for example. They are more structured in networks or cells, and their aim is mainly, I would claim, political. That at least is the logic of the differentiation in the Swiss legislation. Obviously,
yes, the Yakuza, like in Japan and other organizations like the Indonesian cells, where do they match into?
I would rather, traditionally, when you talk to the prosecutors that are concerned with organized crime, they tell me that they're in the first group. They see them rather as hierarchical and clearly structured cells in general. That's at least what the prosecutors told me, but we can discuss that later. Would you agree? Would you rather see them as cells?
I was just curious why you only had those nominated, whether you were restricting your talk.
No. I'm just
examples.
They're examples, and that they're the ones that were most prevalent in Switzerland because they were just next door. But obviously the Russian mafia and the Japanese, they have links to Central Europe too.
Thank you.
Obviously, terrorism does not necessarily have to take place in an organized network. You have these lonely wolves like Timothy McVeigh, for example, in the Oklahoma bombing, or in this terrible terrorism attack in Norway by Anders Breivik. There you had one single person basically that was not organized and in a larger group, at least what we know. Now let's get to the second point, to the empirics. This is a good friend of mine, Umberto Pajarola. He's a prosecutor specialized in organized crime, and I usually introduce him to my students as the best paid unemployed person in Switzerland. Because my claim obviously is that there is no such thing as organized crime in Switzerland, and that the prosecutors are just making this up to justify their work and to justify all the measures that they're imposing. Obviously, he's not at all agreeing with me. He's basically sending me pictures like this of an Ndrangheta cell that has been meeting in Frauenfeld, in a small city in Switzerland. Here again, all I see is some men sitting at a table having a beer. So it's debatable whether this is already qualifies as a criminal organization. 2 weeks ago, this man here was arrested in Zurich. He is a large-scale, or allegedly a large-scale drug dealer who's involved in all sorts of criminal activity. But again, it's one person, one drug dealer. Yes, that he is, but what does that prove? Is he really part of a criminal organization? We don't really know that. A colleague of mine from the University of Basel rightly said that it is extremely difficult to arrive at representative statements on organized crime. And nevertheless, and this is hilarious, this is the Swiss federal council, this is our government. And at the time in 1993, when they enacted this legislation on organized crime, so what they did, I'm going to read this to you because I find it hilarious. The Federal Office of Justice has commissioned a study on the threat posed by organized crime. Based on an extensive analysis of literature, so they have read books, and an in-depth interviews with the police. So what are the police going to tell you? Obviously that there is a lot of organized crime. Hypotheses on organized crime were developed, and the study, however, and this they admit, does not claim to be scientific. Nevertheless, increased vigilance is indicated. So basically, and you really have to stop here for a moment and think about that, they admitted that they knew absolutely nothing empirically about organized crime in Switzerland, and yet they introduced this entire legislation that I'm going to present you afterwards. So basically, we have really an entire building, or an entire city, if you will, built on sand. There is no evidential basis for that, at least for the mafia-style violent organized crime. What we do have, however, is solid numbers, and this is the numbers on convictions that we had since the 1990s for terrorist organizations and criminal organizations. This looks quite impressive at first sight, you know, with the convictions peaking in 2009. But if you put it in a larger perspective and compare it to other economic crimes like theft, for example, it's virtually non-existent. It's a flat blue line that you can hardly see at the bottom. Or if you take just 1 year, 2021, you had over 6,000 convictions for theft. You had 2 for participation in criminal organizations and some 500 in money laundering. So Trudy Gerster, she's the most famous fairy tale teller in Switzerland. And I always say that Umberto Parola is the most famous fairy tale teller when it comes to organized crime. And obviously, I'm being provocative here. I know that this is, but my main point is that this entire legislation has a very thin empirical basis, and more research should have been put into trying to find out what the structures are within Switzerland. Now let us turn to the second part, to the strategy, and to these four P's. Now, these features, I would claim, they more or less can be shown in throughout different jurisdictions. America being one example. So if you look at again the Obama report on organized crime, you find as aims that they want to strengthen interdictions. So basically, this is a prohibition part of the measures. They protect their financial system. That's about the proceeds, and they strengthen prosecution. Excuse me, and build international cooperation. That's the criminal justice authorities part, or the prosecution part, and then the investigation and enhanced intelligence. That's the police and secret service part of these strategies. So more or less, I would claim you find these parts of the strategies throughout different jurisdictions, at least in Europe. I'm curious to hear how you see this here in Australia. Now let's look at them a bit more closely. Prohibition first. I'm going to highlight, these are all the substantive criminal law and prohibitions that in a wider range concern organized crime, but I'm only looking at 2 of them, at the acts preparatory to the commission of an offense and to criminal and terrorist organizations. Few people know that in the 1970s, Switzerland has been the target of outrageous terrorist attacks. On February 21st, 1970, at midday, Swiss Air Flight 330 took off from Zurich to Tel Aviv. Shortly after takeoff, a bomb detonated in the cargo compartment. The crew tried to turn around the flight, but the Coronado flight crashed near Würendingen, and all 47 passengers and crew members died in that attack. George Habash, the then leader of the Popular Front for the Liberation of Palestine, PFLP, claimed responsibility. Later on, two of the suspected assassins, Kaddoumi and Jawher, were identified by the federal police, but they were never arrested and tried for these crimes. In the same year, roughly 6 months later, in September 6, 1970, the PLFP again hijacked 3 planes, one of them again being a Swiss airplane, and had them land in Saqqa in Jordan. And the passengers were then first held hostage, but then released in exchange for imprisoned Palestinian activists. And then you can still watch this on YouTube if you want. These planes were blown up in the desert. So it's fair to say that our government, the Federal Council in this whole crisis, was in over their head. They didn't control the situation at all, and it became clear that something needed to be done. In 1995, here you see Carla Del Ponte, our then Attorney General. She tried to set up a new prosecution, but she states the case a couple of years later. These people could no longer be tried. So as I said, Switzerland had to act. That became clear through these attacks. But the question really is, how do you combat organized crime through, we're still in the prohibition section, so how do you combat organized crime through substantial criminal law? And the answer is by extending criminal liability ratione tempori, so on a temporal, on a time level, and on a personal level. So basically, if you look at the core problem that every combating of organized crime has, so you always have an offender, the small offender, the small fish, if you want, the person in the front who does the dirty work. That's what the classical criminal law is concerned with. You know, the persons who actually commit the crime. Sometimes they're aided and abetted by accomplices. But the real deal is the big fish behind them. You know, you want to catch the ones that are sitting at their tables but calling the shots. And how do you do this? Well, one way to do it is to extend criminal liability on a time frame to a point that you can start prosecuting or holding people criminally liable at an earlier point before these acts happen. So if you look at Article 260 that is on acts preparatory to the offense, you know, you need technical and organizational measures that indicate that the offender intends to commit the crime. So you start at a much earlier point. Criminal liability starts at a much earlier point. So if you look at the plane crash in Würendingen, the George Habash at some point, you know, had the idea, then they hatched a plan for this attack. At some point, you know, they needed to do these organizational measures. They needed to get bombs and maybe find out which planes they were going to attack. And at some point, you know, the plane took off, the bomb detonated. They tried in vain to turn it around, and then the plane crashed and everybody died. Obviously, the more you get to the right, the more you come to the classical field of the criminal law. You know, we're concerned with actual harm happening, or in some in code offenses, you look at attempts to do that. But what this new Article 260 did, and they went further along the line. They went further back. You know, they criminalized these illegal preparation. operations. So that was one strategy to extend criminal liability on a time frame to the earlier phases. A second strategy is to widen the circle on a personal basis, so to include more persons, not only the offenders, but also the organizations behind them. Here again, you can look at our provision 260, that is about criminal organizations. Here, the mere support of such an organization is enough. So you don't need to be involved or prove that somebody is actually involved in the act that is carried out at the front, but it's enough to show that this person has supported such a criminal organization. Now, the second strategy aims at the proceeds of the crime. Now, here the obvious idea is that crime must not pay. You know, you want to cut the financial resources of this criminal organization, and also here, well, in Switzerland, we do that through a provision on money laundering and through a provision that allows confiscation of assets of criminal organizations. Now, here too, Switzerland had to learn its lesson really the hard way. You might have heard of the pizza connection, which was a scheme drawn up in the 1980s. Morphine base was from Turkey, was processed into heroin in Sicily, and then the heroin was shipped and sold in the United States, and the money collected was then collected in mafia-controlled pizzerias in Queens, New York, hence the name Pizza Connection. So we were not directly involved with these criminal activities, but what did the Swiss do? Obviously, what the Swiss do best, they collected the cash. So the narco dollari, as they were called, you know, the drug money, at least 40 million of these Pizza Connection revenues were washed were transferred to Swiss bank accounts and washed here in Switzerland. At the time, this did not constitute a criminal offense, and this was one of the cases where huge political pressure was imposed on Switzerland to do something about it. Obviously, we were helping the criminals of the world to harbor their money here. Now, this is the case that really the straw that broke the camel's back, if you want. The person to the right you see here is Mr. Kopp, and he was married to the first female federal counsel in Switzerland, Elisabeth Kopp. And he was also a board member of Sakachi Trading Company, and Sakachi Trading was charged with having washed 1.4 billion US dollars, I think it was, no, Swiss francs, in a Lebanese Turkish drug trafficking organization. So that was a huge case that once more laid open that our legislation on money laundering was nowhere near a satisfactory level. And so this led to her resignation because she tipped off her husband. I mean, he then stepped down, but this really got things going. And within a couple of months, they had to enact this legislation after that. And here, the logic is quite obvious. You know, we're not after the persons, but we're after the proceeds of the crime. And the idea, obviously, is if you cut the financial resources, if you take that away, you're taking away the main aim of these organizations. Money laundering has been introduced. So basically, if any act that frustrates the forfeiture, so that hinders the states seizing the money of assets that one must know that originate from a felony, that constitutes money laundering, and that has been applied ever since. Switzerland, obviously, as I already said, didn't do that because they wanted to create a better world, but because they were under huge international pressure and had to act upon that to no longer be looked at the entire world as just the ones that harbor the money from criminal institutions all over the world. There's still a far way to go. this year, this summer, Credit Suisse again has been convicted of money laundering, and here not of the individuals themselves, but here the company. The only little problem here is if you find Credit Suisse with 2 million Swiss francs, that's the equivalent of a parking ticket for them. So that's not really going to deter them. And if you do it at that scale, so here also we still need to step up our legislation a bit to have some effect on that. Now, Now the third strategy is about prosecution, strengthening the prosecution. Now in Switzerland, we do that on 3 levels. The criminal justice authorities themselves have been strengthened. The coercive measures, so the measures that can be taken by the prosecutors, have been widened, and the prosecutors have been provided with more prosecutorial discretion, allowing them to engage in deals, plea bargaining deals with criminals, alleged criminals. So at the first level, here you see the Attorney General of Switzerland, Stefan Blättler. He is part of what was created in order to combat crime. An entire structure of federal jurisdiction, of Switzerland-wide jurisdiction, was created to combat organized crime. Because, as in this country as well, our criminal justice system is organized state by state. We have 26 of them, so you can imagine how effective that was in combating organized crime. And so basically, they thought, they need to reunite this and do this at a federal level. And also in international mutual legal assistance. The second part is about coercive measures. So basically, they have a lot of powers in seizing and freezing the assets that can later be confiscated. And they have a whole array of secret surveillance measures. You can survey communications, you can survey the banking, and you can, of course, also resort to undercover investigations. The Federal Council said in 2003, undercover investigations are indispensable in the fight against organized crime. That's what everybody thinks. And as we all know, nothing can go wrong in undercover investigations. This is probably the most important slide for me that I'm showing you today. That's really the main point I want to stress. And that's the interaction between the substantive criminal law on one side that I've shown you before, the widening in time, but also in persons for these criminal prohibitions, how this interacts with the criminal procedural measures that they can take. So basically, here you can see in the classical realm, the prosecution comes into the equation after the crime is committed. Usually, traditionally, after somebody is killed, for example, they start to seek the secret surveillance of the person that could be suspected and try to find the offender there. Now, what these substantive criminal provisions that I've shown you before do is that they widen not only the range of the substantive criminal law, but they also widen the range of all the coercive measures. Because you have these substantive provisions that let the criminal activities begin even earlier. You can start much earlier, much before the crime. You can start surveillance. You can start undercover to engage undercover agents. So basically, the whole thing shifted the criminal procedure into a much earlier stage. Prosecutors can now act preventively much more than they did before. And this also kind of explains that the empirics that I showed you in the beginning, they're not really the point. These substantive criminal law provisions, they lead to very few convictions. But maybe that's not the point. That's not their main aim. Their main aim is a secondary one. They serve the coercive measures, because if there is a criminal act that starts earlier, the coercive measures can also start earlier. So I would claim that this is probably the main function that the substantive criminal law has, is to enable a much wider range or a much earlier interference of the criminal justice authorities. So I hope I was able to make this point clear, because that's really one of the main points I want to stress today and also to discuss with you afterwards. Now, on the third level, prosecution was entrusted with so-called special procedures. We have penal order proceedings and abbreviated proceedings. They're the main focus of my research I did in Switzerland. Basically, if you look at the structure of the Swiss criminal procedures, we have two phases. We have a preliminary proceeding where the prosecution is in charge, and then after the charges are raised in the middle, then the court is in charge of the criminal proceedings. And so now what these special proceedings do is they kind of cut out the court and give the entire responsibility to the prosecution. The prosecution can issue penal orders, can propose a judgment, and they can try to strike deals with the offenders. So they can seek guilty pleas by the offenders, and in turn they can offer charge sentence or fact bargains, lesser sentences or lesser charges. Now, obviously, this poses a substantial problem. If a prosecutor sees a 50% chance that she's going to get a 10-year sentence, let's say for participation in a criminal organization, that leads to a discounted average of punishment of 5 years. Now, what do you think the prosecutor offers the accused in these in such a special proceedings? What would a typical offer be?
Plead guilty to a lesser charge.
Plead guilty to a lesser charge, and what sentence would you assume on average that they would propose here?
My maths isn't good. 7 years. I don't know. You said
no, seven. Then you would always take it to court. No, and if they were adhering strictly to the mathematics, you would expect 5 years. So then they wouldn't have to take it to court. But they offer much less than that. And then they for a rationally acting accused person, they make it very, very hard to refuse that offer. Because they say, if I take the chance to take this whole thing to court, I have a 50% chance of ending up with a 5-year sentence. And the prosecutor here offers me, although I think that I'm probably innocent, or they can't prove anything, and they offer me 2 years. So this disproportionately disadvantages innocent offenders. And well, there is a whole lot wrong about this system, and I assume you have the same problems here too. But my main point is that by giving these prosecutorial powers to the prosecutors in the pursuit or in the combating of organized crime, they get more convictions, but on very thin factual basis. These procedures are set out to bridge the problems in proof that you have typically in these cases, and they do that by offering lesser charges and making it much harder for the accused to refuse that. And the last typical measure would be to introduce some sort of crime witness rule. Italy and the USA, they have extensive crime witness rules. We've discussed them at length, but then finally decided not to introduce full-blown crime witness rules. So basically, you don't get immunity for crime witnesses, but you just get a mitigation of the sentence. And now the fourth strategy is in policing. Now, here again, Switzerland has a notorious history. Throughout the 20th century, the Swiss government has drawn up a large-scale surveillance of the entire Swiss population. So in the 1990s, it came up that close to more than 900,000, close to 1 million secret files, so we call them fiches from the French word, were gathered of the Swiss citizens and really on a large scale, the police and the secret service authorities, surveyed the entire population. After this was discovered, this came to a huge scandal, and then the police was put under surveillance by the Federal Council. Now, you would think that the Swiss are thus very skeptical about secret service activities. The answer is they worried for a moment, but they've completely lost that track now. So basically here we're in the same logic. Again, you have the traditional system with the judicial police, and now the new system acting further to the forefront as well. And now you can hardly see it. And they can even before that the criminal law starts to act on the preparatory acts or on the criminal organization acts, the police can do investigations, can do surveillance measures even before that point. We have, over the last 2 decades, we had extensive legislation that was introduced here. I'm only going to look at the last one, the police law to combat terrorism. And here they've introduced all sorts of measures that allow basically all sorts of surveillance, but also you can arrest these people, you can track them, and you can even detain them. So basically they have the entire array of measures they can take. So you would have expected that, only 30 years after the Swiss Watergate scandal, after this surveillance scandal, that the Swiss would still be skeptical, but the truth is that they're not. They have bought into this logic of, you can't put the price on safety, better be safe than sorry, and so on and so forth. That more than 60%, almost 60% of the population have accepted this new law that has given extensive powers to our secret service agencies. Now, let me summarize my findings. I've shown you some definitions. I guess that the features of the definition are the same internationally. I personally find that the empirical basis for this all is very, very thin, at least in the mafia style section of the crime. We have more substantial evidence that there is money laundering going on in Switzerland. I think that cannot be denied. But the actual criminal activities, I would say, they're not proven to my conviction. In the strategies, I've shown you the 4 Ps, and again, the most important one is that you really take this as a take-home message, that the extension of the substantive criminal law also leads to an extension of all the prosecutorial measures that can be taken. This really widens the traditional field of the prosecution. And now let me come back to my example in the beginning. You might ask, why was the police allowed to monitor the online activity of this man? This man, all this man did, he boarded the plane to Istanbul. He did some internet research and he boarded the plane to Istanbul. Is that really already a criminal offense, or should that be a criminal offense? And maybe even I was monitored by the Secret Service. I don't know. The question then is, why wasn't I arrested? You can only guess. I want to end on a wider thought, and that is that this whole discussion about organized crime and combating organized crime is really resulting in quite a corrupt bargain. Because for a very uncertain promise of more safety, that's what they always say, they say, we have to do this because we want to prevent crime. We are trading in a very certain loss of our civil liberties, because all these surveillance measures and the infringements of our liberties, they're quite substantial. And that, I think, is a really bad deal. And that's it.
Thank you.
We'll take turns between online and the room, and we'll start here in the room.
I concur with all the proposition put up in that last slide, and I'm wondering if you also have any awareness of the connection between what you highlighted in the number 3 point, where people are being offered lesser durations in prison,
Yes.
with the construction of prisons? Because here in Queensland, at least I'm aware, and also I think in other states, there is this sort of push to build more and more prisons as a solution to crime. But it appears to me that it's only a solution to putting more money into the hands of developers of the prisons and also the operators of the prisons. And really, there's no reform happening within the prisons. Often, in fact, people come out worse criminals than they were before they went in. And shouldn't we actually be looking to rehabilitate people as opposed to just create a means to giving more money to developers?
Yeah, I totally agree. I always say to my students, you know, more police means more crime. And obviously that's very provocative as well. It means more police means more protected crime. And it's the same with if you create more prison space, then this prison space needs to be filled, and you have more incentives to pick up people and lock them up. So I totally agree with that. Although I must say that at least in the Swiss criminal justice system, there is quite some emphasis placed on reintegrating people. So it's not just about locking them up. So we're kind of looking past that point and trying to you know, to really prevent them from doing reoffending by really closely monitoring them after they're released. So at least on that I cannot complain too much. Although John Ege, who's also here, will probably not be totally happy about what I'm saying, but I'm happy to discuss. Yes, please.
Thanks very much, and super impressed that you gave a talk after a 24-hour flight. I'm just wondering if in one of my classes, we do a whole class on a debate about whether cybercrime groups or networks can be considered organized crime. In the Swiss law or in the Swiss sense, would that apply? And also, do you think cybercrime groups can be considered organized crime?
Not under the Swiss definition.
And your definition?
Well, we have cybercrime units. They're working closely together with the organized crime units. I would say some of them are certainly within the field of organized crime, but I would say that they do not fit under the stricter definition of criminal organizations. I would say that they're rather loose groups of maybe in some cases, you know, just a group of computer nerds who try to do online scams and are successful in that. That is a form of organized crime, but probably not of criminal organizations. Yes, please.
Do you find that, I'm not sure about where you're from, about Europe in this in general, but as far as actual like the crossover between like civil officers in organized crime, you were talking about they like to get political control. Is there infiltration of public service, for example, of people that are criminal and that are stopping and halting investigations? Like, you know, you mentioned a few cases that just, you know, died. So is there some crossover there where people are actually thwarting that? Because we've had a major issue with our CCC, which is our Crime and Conduct Commission, where they've actually had to stop police and army people getting involved in the criminal investigations because they're actually running amok and not doing the right thing. So there's a bit of infiltration going on.
So are you talking about infiltration of about the undercover activities of police in these criminal organizations, or the criminal organizations infiltrating people within the state?
The latter, yes. So
yes.
the criminal, so then organized, going inside even the criminal justice system.
There really has been no solid proof of that. You know, that's what the federal Council tried to find out with the study they commissioned. You know, they tried to find out whether organized crime had any measurable influence within criminal justice authorities, or whether the state was in any way corrupt, and there just weren't any signs for that. You know, this doesn't mean that it's not happening, but there was just no empirical evidence for that.
No way to measure it.
No. there's no way to measure it. And also, I think, I mean, we're less prone to at least large-scale corruption because at least I would claim at some level our criminal justice authorities in general, they're rather well paid, you know, they have solid jobs, so that they're not that much inclined or dependent on making additional profit. And I'm not saying that it's not happening, but it has just not been proven, to my knowledge thus far. Yeah, no, yes, you go first.
Mine kind of follows up on that. Is there any anti-corruption independent body?
There is not. I gather that you're about to introduce one in this country, and I congratulate you on that. Probably, if you had one, they would finally get one of these findings. But thus far, the going after corruption is there just the special units of the prosecution that are also entrusted with going after corruption. One of them being in the federal prosecutor's office at the Attorney General, but they're not in themselves independent institutions. No.
The powers under the prosecution special proceedings. So two questions. Does it expand to other types of crime, or is that only organised crime? And then secondly, does the court have a power to intervene on a plea bargain if they think it's entirely inappropriate?
Very good question. The first answer is yes, it applies to all crimes, not only to organised crimes. So basically, penal order proceedings, they're capped at 6 months of imprisonment. But any crime can be tried. Even some negligent homicide cases are tried with penal orders. There is no compulsory court oversight over, and that goes into your second question, into the penal orders. So with the penal orders, the defendant himself or herself has to take it to court. So they have to object to it, and then a court looks at it. But there is no automatic control of it. And it's a little bit different for the second group, for the abbreviated proceedings. They are up to 5 years of imprisonment, and there you have a mandatory control of the bargain by the court. But the penal order proceedings, they account for about over 90% of all proceedings in Swiss law. So in Swiss law, you can say that 3 out of 4 prison sentences are issued by prosecutors themselves. So only in 1 out of 4 cases, the court actually issues prison sentences.
And so they're up to sentences of 6 months.
Yes.
And so we then get into the problem of short sentences. Are they a good or a bad thing?
Yeah, obviously, I mean, we could debate that a lot. I mean, short sentences, at least they're executed in a way that you don't, for example, you can do that overnight. You know, you can still stay in your job and you just go to prison overnight or on weekends. So, I mean, they're organized in a way that do not disintegrate people totally, but still, you know, it's a prison sentence that is issued without any independent court being part of the proceedings. So that's in itself, I think, quite problematic. Yes.
Just following on from that, does that mean the state itself is imposing the sentence?
Yeah.
At the prosecution, there's no court involvement at all.
No.
So there's no separation of powers there really.
No, totally. No, we're back in the Middle Ages. No, I really claim this. No, this is quite stunning to hear that. You know, I mean, these penal order proceedings, you have them throughout jurisdictions for small crime. You know, for speeding offences, for petty crime. That's not really a problem. But we're talking about serious crime here that, you know, that can lead up to 6 months of imprisonment, and that is imposed solely by the state, solely by the prosecutor, without any judicial control. That really is, yeah, that's a huge problem.
Do you have the adversarial model?
No.
Okay.
No, it's I mean, depending on how you define it, but it's I would rather say it's the inquisitorial model. Yes. Yeah. You just in the back.
Yes.
You have a question? Or? Okay.
I might throw in.
Yes, go ahead.
Question, Mark. I was a little bit surprised by one thing in your presentation, and I'm not sure if others in the room online picked up on this. you kind of throw organized crime and terrorism a little bit into the same basket. I personally think that's not a good thing to cluster them together, and partly because of jurisdictional issues that's kept apart because the organized crime matters are mostly in the hands of states and territories, while terrorism has been delegated to federal authorities. But is that sort of, and I know that some of the measures are alike that are used for one or the other, but I think we've kept them apart, and I think on the debate around these phenomena as well, which I think is a good thing. But I'm getting the impression from your talk that this really is a little bit lumped together in the Swiss law. Is that right?
Yes, I had them, I really insisted with my students that they strictly separate organized crime from terroristic crimes. But the fact of the matter is that they're now lumped together in this provision. They have the same measures attached to it, all the same prosecutorial powers. So it's hard. I mean, it's still conceptually, I totally agree with you that you have to keep them apart, but the Swiss legislation doesn't. And so, and sometimes it's hard to tell whether they classify it as terrorist or as an organized crime, a criminal organization of the mafia style.
With a few, yes, Jeremy.
Actually, yeah, just kind of leading on from the terrorism sort of theme. Like for example, in Australia recently, a lot of our recent convictions or thwarted terrorist events were by individual actors and not by larger organizations, but they were always, a lot of them are like ideological, being inspired by the call to arms from IS or far-right organizations or whatever. Does legislation like the Swiss's in this case, does it capture like that, like this sort of nebulous idea of an organization?
Well, obviously the prosecutions that deal with these cases always try to frame these lone wolves as sleepers of larger cells. So basically they say, well, you might think that this is a lonely criminal that has just, put forward this attack by him or herself, but in fact, he or she is part of a larger organization that provides them with the necessary funds and organizational matters and also with the ideological background of it. So yes, the Swiss prosecution tries to frame this in a larger organized perspective, but here again, I'm quite skeptical of this narrative. I think that in many cases they really are lonely, desperate persons who just commit crimes that are inspired by maybe other organizations, but that are not in any way guided or pushed by them. Yeah.
It will be time for one. We have two more questions, and we'll do those. And people online, if you have any questions, we have a few more minutes before we wrap things up.
I was just going to ask what the cooperation between countries is like, because, in Swiss, you can get a sentence of 6 months or 5 years imposed by the prosecution. But if the majority of the acts are occurring in a different jurisdiction, like how do the countries talk to each other about who's going to prosecute it? Because you might get a much higher penalty somewhere else.
Before this talk, before I left from Switzerland, I talked to Umberto Pajarola again. I mean, he's really a close friend. Doesn't seem to have, I'm bashing him all the time, but he's bashing me. He says I'm just an ivory tower academic who doesn't know anything of the world. And so I eventually always call him and say, like, what's up, what's going on? And on this very point, he said that international mutual legal aid and the way that the countries work together, this really needs to be improved. This is at a terrible stage. At least mutual legal aid in Switzerland is terribly outdated. It comes from a time where you really wanted to protect your state from any outside interference into your criminal justice system. So it always has to go through the Federal Office of Justice, and this takes forever. And so basically, I mean, if you're acting as a criminal on different national stages, you're very hard to capture, and this cooperation is far from working perfectly. Yeah.
We have a question from Gianmarco. Buongiorno, Gianmarco. Good morning, Venice.
You're still muted.
Okay, here I am. Good morning, everyone. Thank you very much for the lecture. I'm Gianmarco Bondi from the University of Ferrara. I was interested in how, even though we are close as countries, there is a totally different approach to this criminal phenomenon. Because, as you, I'm sure, know, Italy has very differentiated kinds of unlawful associations in the criminal code, even within the very notion of, say, basic association and also mafia type or terrorist organizations. So I was wondering whether, can you confirm that there is no equivalent for the mafia type unlawful association crime that there is in Italy in Swiss law? And if, if in your research you've ever found that there was an issue in criminal cooperation due to double criminality for that, because usually in Italy, Switzerland is portrayed as a safe haven for money laundering, especially. So perhaps historically there's been a push to somewhat solve these sociological issues. Thank you very much.
Thank you, Gianmarco, for these questions. Yes, I know that in Italy you have this criminal organization, the tipo mafioso. We're totally aware of that. We don't make these elaborate distinctions. The Swiss legislature thinks that our general rule that now also encompasses terrorism is enough for that. I doubt that. I think structurally we have here a couple of issues, and your provision on mafia-style criminal organization is much stricter. And the second question was about the double criminality. That's one thing, you know, I stressed this in my presentation, that one influence of the substantive criminal law is on the provisional measures. You know, if you extend the substantive criminal law, you also extend the coercive measures you can take. But this is also true, of course, for mutual legal assistance. You need double criminality. You know, it needs to be a crime in both countries in order to grant legal assistance. So that also was a second driving factor in extending this substantial legislation, because before that we couldn't even give mutual legal aid, because being a member or supporting a criminal organization was not a crime in Switzerland.
Thank you, everyone, and have a lovely night.
Thank you.